Good day everyone, I am Aris Kenneth I. Laglemas and I am going to report about List Section 4, Common Carriers. In this presentation, we are going to tackle the fourth subsection of common carriers. The first subsection is General Provisions. Article 1732 explains that common carriers are entities that transport passengers or goods for compensation and offer services to the public. One example of this is a bus company providing transportation for the general public as a common carrier. The next article is Article 1733. It explains that common carriers must exercise extraordinary diligence to ensure the safety of passengers and goods. For example, a logistic company must secure fragile goods with extra care during transit. Subsection 2. Vigilance over goods. Article 1734. This article explains that common carriers are liable for goods unless loss or damage is caused by certain exceptions. For example, number 1, flood, storm, earthquake, lightning, or other natural disaster or calamity. 2. Act of the public enemy in war, whether intentional or civil. 3. Act or omission of the shipper or owner of the goods. 4. The character of the goods or defects in the packaging or in the containers. And 5th, order or act of competent public authority. The next article is Article 1735. This explains that if goods are lost or damaged for reasons not covered by Article 1734, the carrier is presumed negligent unless they prove extraordinary diligence. For example, a carrier loses a package and they must show evidence that they handled it with utmost care to avoid liability. Article 1736. This explains that the carrier's responsibility begins when goods are received for transport and ends when delivered to the rightful recipient. For example, a courier company is responsible for a package until the recipient signs for it. The next article is Article 1737. This explains that the carrier's duty of extraordinary diligence continues even when goods are temporarily stored or unloaded during a transit. For example, goods stored in a warehouse during a layover remain under the carrier's responsibility. The next article is Article 1738. This article explains that the carrier is liable for goods stored at its destination until the consignee is notified and had a reasonable opportunity to claim them. Example is that a shipment stored at a port remains under the carrier's care until the recipient is informed and can pick it up. Article 1739 explains that for exemption due to natural disasters, the disaster must have been the sole cause of loss and the carrier must have taken steps to minimize the damage. For example, a flood destroys the goods on a truck. The carrier must then prove that they took measures like rerouting to avoid liability. The next article is Article 1740p. This article explains if a carrier's negligence causes delays, they remain liable even if a natural disaster subsequently damages the goods. For example, a train delays the shipment and a storm damages the goods. The carrier is liable because their negligence contributed to the loss. Next article is Article 1741. This article explains that if the shipper contributes to the loss or damage, but the carrier's negligence is the main cause, the carrier is still liable, though the compensation may be reduced. For example, a poorly packaged box, which is the shipper's fault, is damaged due to rough handling by the carrier. The carrier is still partly liable, but the damages awarded to the shipper will be reduced. Article 1742 explains that even when goods are inherently prone to damage or poorly packaged, the carrier must take measures to minimize loss. For example, a carrier handling perishable items must use refrigeration even if the goods are poorly packaged. The next article is Article 1743. This explains that the carrier is not liable if goods are destroyed or seized under a lawful order from public authorities. For example, goods are confiscated during a custom raid. The carrier is not responsible if the seizure is legal. Article 1744 explains that a written, reasonable and fair agreement limiting the carrier's liability is valid under certain conditions, like 1. In writing, signed by the shipper or owner, or 2. Supported by a valuable consideration other than the service rendered by the common carrier, and 3. Reasonable, just, and not contrary to the public policy. For example, a shipping contract states liability is capped at $500 for damage, and provided that the shipper agrees in writing and the terms are just. Article 1745 explains that stipulations that are unjust, unreasonable, or against public policy, like 1. That the goods are transported at the risk of the owner or shipper, 2. That the common carrier will not be liable for any loss, destruction, or deterioration of the goods. 3. That the common carrier did not observe any diligence in the custody of the goods. 4. That the common carrier shall exercise a degree of diligence even less than that of a good father of a family or of a man of ordinary prudence in the vigilance of over the movable transported. 5. That the common carrier shall not be responsible for the acts or omissions of his or its employees. 6. That the common carrier's liability for acts committed by thieves or of robbers who do not act with grave or resistible threat, violence, or force is dispensed with or diminished. And 7. That the common carrier is not responsible for the loss, destruction, or deterioration of goods on account of the defective condition of the car, vehicle, ship, airplane, or other equipment used in the contract of carriage. For example, a clause stating that the carrier isn't responsible for theft unless there is extreme violence is invalid. Article 1746 explains that if the carrier forces a limiting agreement as a condition to transport goods, the shipper may nullify the agreement. For example, a carrier refuses to ship unless the shipper agrees to an unfair liability cap. The shipper can challenge this clause. The next article is Article 1747. This explains that if a carrier unjustifiably delays transport or changes the route, limiting clauses cannot protect them from liability. For example, a carrier delays delivery for personal reasons and goods spoil. Limiting liability in this situation isn't enforceable. The next article is Article 1748. This explains that agreements limiting liability due to delays from strikes or riots are valid. For example, a clause in a contract states that a carrier isn't liable for delays caused by labor strikes. Article 1749 explains that a clause limiting liability to the value stated in the bill of lading is binding unless the shipper declares a higher value. For example, a shipment listed as a worth of 1,000 pesos in the bill of lading limits liability to this amount unless a greater value was declared. The next article is Article 1750. This explains that agreements on fixed compensation for loss or damages are valid if fair and reasonable. For example, a contract stipulating 200 pesos compensation for loss package is valid if agreed upon and just. Article 1751 explains that a carrier's monopoly on a route is considered in determining if liability limiting terms are fair and aligned with public policy. For example, a sole ferry operator's terms might face scrutiny for fairness due to the lack of competition. The next article is Article 1752. This article explains even with liability limiting agreements, carriers are presumed negligent in case of loss unless proven otherwise. For example, goods are lost during transit. carrier then must prove they exercise diligence despite the limiting clause. Article 1753 explains that the liability rules of the destination country apply to international transport. For example, goods shipped to another country are governed by that country's transportation laws. Next article is Article 1754. This article explains that Articles 1733 to 1753 also apply to passengers' baggages not in their personal custody. Other baggages follow hotel keeper liability rules. For example, checked luggages on an airplane falls under these articles while carry-on baggage may not. Subsection 3. Safety of passengers. Article 1755 explains that common carriers must ensure passenger safety to the highest standard of care and caution. For example, a bus company must regularly inspect its vehicles and trains drivers to prevent accidents. Next article is Article 1756. And this article explains that if a passenger dies or is injured, the carrier is presumed at fault unless extraordinary diligence is proven. For example, a train incident injures passengers. The operator must then demonstrate adherence to all safety protocols to avoid liability. The next article is Article 1757. This explains that passenger safety obligations cannot be waived or reduced by disclaimers, tickets, or notices. For example, a notice on a ferry stating "travel at your own risk" does not absolve the carrier of responsibility for negligence. The next article is Article 1758. This explains that liability limitations for free rides are valid for negligence but not for gross negligence or willful acts. Reduced fare does not justify liability limitations. For example, a school bus offers free transport but cannot escape liability for a severe accident caused by reckless driving. Article 1759 explains that carriers are liable for passenger injuries or death caused by employee negligence even if the employee acted beyond authority. For example, a reckless bus driver causes a crash. The bus company remains liable despite prior training and supervision. Article 1760 explains that liability for passenger safety cannot be waived by notices, tickets, or other means. For example, a ticket stating no liability for accident has no legal effect. Article 1761 explains that passengers must act responsibly to avoid harm to themselves. For example, a passenger leaning out of a moving train window violates this article. Article 1762. This explains that passenger negligence does not entirely prevent compensation if the carrier's negligence is the main cause of harm, but damages may be reduced. For example, a passenger ignoring safety instructions is injured in a preventable crash caused by the driver. The compensation amount is adjusted. Article 1763. This article explains that carriers are liable for injuries caused by other passengers or strangers if the carrier's employees could have prevented the harm. For example, a bus employee fails to intervene in a fight and a passenger is injured. The carrier is still liable. Subsection 4. Common Provisions. Article 1764. It explains that damages in such cases follow specific laws on damages, including compensation for passenger death due to a breach of contract. For example, the family of a passenger who dies in a plane crash is entitled to damages under relevant laws. Article 1765. This article explains that the Public Service Commission can revoke a carrier's certificate for repeated failure to meet extraordinary diligence requirements. For example, a ferry operator frequently involved in accidents may lose its operating license after a public inquiry. Article 1766. This explains that matters not covered by the Civil Code are governed by the Code of Commons and special laws. For example, disputes about shipping goods internationally may refer to maritime laws outside the Civil Code. That is all for my report. Thank you. Once again, a good day to everyone.